consequence of that silence. What does that mean? That means if you turn to the next page, 437, second line, 437. Therefore, the consequence of permanent nature, i.e. incapacity, following a final and binding decree of court of civil jurisdiction, now very important these words used, is the ordinary and lawful outcome of civil litigation. The learned bench was of the view that the only consequence which would follow as an ordinary or natural consequence is one of permanent disqualification. That is where the mistake is made, and I'll show. But let me just complete the reading of this judgment, because there is another contradiction in the judgment. If your lordship may kindly see page 442 of the judgment. सर अगर पैरा 32 आपके पास है, उसमें कोई 10-12 लाइनें छोड़ के वर्ड शुरू होते हैं considering. If your lordship may see, it's about. Now your lordship has seen it is based that there is no intention. That is why we are drawing a consequence. Now what does the judgment say? Considering that the Constitution does not fix the period of incapacitation of such judgment, of such a judgment debtor, shows a clear intention, your lordship may mark this, that the lack of disqualification under Article 62 1F should extend so long as the declaration of law envisaged in Article 1F remains in the field. If such declaration is final and binding, then the incapacity to contest election to any of the legislatures provided by the Constitution become permanent. Now they've taken another leap. They accept that there is absence of intention. They say we will draw a consequence, then self-contradict themselves by saying there is a clear intention that the disqualification is permanent. Now, if your lordship may kindly see para 36, which is at page 444. In the result, we are inclined to hold.
इससे पहले भी ये 4 लाइनें पढ़ी. Judicial mechanism.
जी.
इसी para 35 में.
जी sir. जी. The judicial mechanism in Article 62 1F of the Constitution grants a fair opportunity and adequate remedy for relief to a candidate under challenge to vindicate themselves. Therefore, the permanent, now again the word permanent, incapacity of a candidate for election under Article 1F of the Constitution is not an arbitrary, excessive, or unreasonable curtailment of his fundamental right under Article 17(2) of the Constitution. In the result, we are inclined to hold that the incapacity created for failing to meet the qualifications under Article 62 1F of the Constitution imposes a permanent bar, which remains in effect so long as the declaratory judgment supporting the conclusion of one of the delinquent kinds of conduct under Article 62 1F of the Constitution remains in effect. So there are two terms used. It continues till the declaration continues. If Samiullah Baloch had limited itself to that, maybe then there was a reconciliation. But the use of the word permanent creates.
वो तो क्लियर कर देते हैं ना कि परमानेंट वो यूज कर देते हैं, लेकिन आगे कहते हैं it will remain till such time that the effect is.
Sir, लेकिन permanent bar, but that is why the latter case
अगर
now.
डिक्लेरेशन कोई है परमानेंट तो वो जब हो जाएगा ना, सपोज के सिविल सूट आपका था, फिर अपील हुई, फिर वो फाइनलिटी अटेंड हो गई, तो if the judgment is attains finality, then तो फिर वो परमानेंट हो गई ना.
लेकिन सर यहाँ पे permanence then gives rise to the misconception in later case law where the word used is life. Whereas Samiullah, because of this contradiction, created this problem. But let me come to Azmat Saeed Saab's note, which is much more definitive on this. If your lordship may kindly see page 446 para 3, side marked P. Now he completely eliminates constitutional absence. P. It is clear and obvious that lack of qualification in terms of Article 62(1)(f) of the Constitution is the effect of a declaration by a court of law to the contrary, which is the cause. The obvious, legal, and logical conclusion would be, as long as the cause, the declaration of a court of law holds the field, its effect, the lack of qualification, shall also prevail. Now this is very important. This appears to be the only possible interpretation of Article 62(1)(f) of the Constitution. How can you say that when you say that it is a constitutional silence? That the only possible interpretation of a constitutional silence is what the learned judge is of the view. And he is very, I would say, disparaging of people who might take another view. If your lordship may see the last line, when referring to another article, he says, no sane person could seriously urge to the contrary. Sir, I
hope you're not pleading insanity.
Sir, if this judgment stands, then I would be considered as one of those insane persons. Sir, page 447, para 8.
Paragraph 8.
Ji, sir.
So did they consider other avenues and then by virtue of deletion come to this or this?
Sir, he doesn't. He is not even considering absence. He says absence ka matlab hai कि there must be one obvious interpretation. That is not what constitutional absences mean.
Any judge who disagrees with this judgment would be insane and therefore not able to contest elections under Article 63.
Sir, एक और बात कहते हैं अगर आप
or any counsel or amicus putting forward canvassing the proposition would also fall in the same category.
Sir, I would gladly
cautioning you, Mr. Siddiqui, you tread carefully.
I gladly plead that insanity. एक और warning देते हैं सर, para 10 में जरा देखिएगा.
अभी आप
448.
अच्छा 10 पे चले
448 सर.
आप हमें डरा रहे हैं क्या?
सर मैं क्या करूं, जज साहब ने जजमेंट डराने वाली लिखी है. None of the counsels who appeared before us confronted the elephant in the room, i.e. the obvious interpretation. He has no doubts. There is no silence. Of Article 62(1)(f) of the Constitution is that the lack of qualification to a member is the effect of declaration by a court of law, which is the cause and period of qualification would be coextensive with the period to the cause, i.e. declaration. Now, here comes the warning. None of the learned counsels refuted the aforesaid obvious interpretation, but only sidetracked the issue. So, my lord, anyone who doesn't agree is sidetracking the issue. Now, the problem, this is the problem which Samiullah Baloch creates, is, and that is why I say sustaining this judgment is very problematic in terms of how the Constitution is to be interpreted. Now, when the legislature leaves something to the imagination, there is a constitutional, sir, you are talking about people who have made over 100 amendments in the Constitution, in the 18th Amendment. There is a reason why these constitutional silences are left. And the reason why constitutional silences are left is because, number one, either it is a very touchy issue. That is why the legislature at a particular time doesn't want to take a certain position. And it wants to leave it indeterminate, because putting in a definitive answer in the Constitution would give it a permanent character. That is why constitutional absences, and I now refer.
No, but what's your answer to this constitutional absence?
एक मिनट में जरा अगर पढ़ दूं एक दो पैराग्राफ, मैं पहले जवाब दे देता हूं.
जवाब बता दें कि हमें जरा समझ आ जाए. आपके मुताबिक क्या ऑप्शंस थे?
एक मिनट दिखाइए. to me, when there is a constitutional absence, then that has to be fulfilled by always keeping in mind that there is no intention of the legislature. Whether it's a lifelong ban or a 5-year ban or a 3-year ban. That's the first premise you make. The second premise you make is because you are engaging in judicial interpretation where there is no definitive answer.
No, why don't you use a third interpretation? When there is a constitutional absence or abeyance, the constitution makers intentionally open the field for legislation.
Yes.
Not for constitutional interpretation.
Yes, and any judicial interpretation which is made
which can be changed from time to time.
Yes, sir, exactly. And any judicial interpretation.
But you started off by saying that 232 can't be sustained.
मैं कहा था Samiullah Baloch cannot be sustained.
Okay.
232 will be sustained.
ठीक.
And just building on what the Honorable Chief Justice has said, that is why the constitutional implication which should be drawn from that absence should be such that it should be changeable in the future through statutory interpretation.
Open through legislation.
Yes.
Without taking the cue from the Chief Justice, could you just tell us what you were saying earlier before this comment was made?
I was going to explain.
How would you think this constitutional absence should have been filled? You took the cue and you went on, but before that.
So the solution to
He doesn't want you to agree with me.
To me, another obvious implication of this absence, it is so obvious, is that if there is a court, let us forget about that there is what kind of court should be, can a declaration, if there is a declaration, it should apply to the next election. How can you say, if there is no intention specified in an absence, that this is not one of the logical consequences? You don't even have to go into the time frame, whether you should borrow 5 years from 63 or 3 years from 63.
Let's just to little more focus. I'm more a practical person. Undoubtedly, you and Mr. Bandari are more sort of philosophical.
Yeah.
Does the Constitution prescribe the punishment for murder?
No. No.
The only provision is Article 9.
Yes, of course.
No person shall be deprived of life or liberty save in accordance with law. तो वो उन्होंने specify कर दिया with law, तो Pakistan Penal Code आ गया. But are there other provisions where they leave it open? For instance, and it has been supplemented by subordinate legislation.
So it's such a well-established doctrine. मेरी जो problem है,
नहीं अगर ये लफ्ज accordance with law नहीं होता उधर, ठीक है? So that means there could not have been legislation.
Article 20.
Only the courts could have said it would be death or life imprisonment in Article 9.
Ji.
I don't know, I'm just imagining things. Because
I wouldn't go that far, sir, but it clearly indicates that there is...
No, because they get certain permanences. The Constitution are the guiding lights. It fixes. Some may be a bright light, some may be a little diya, which you have room around it for the Parliament to step in and legislate.
If your Lordship searches the Constitution for the word permanent, perpetual, perpetuity, life, your Lordship will not find it.
Har change eventuality mein phir constitutional amendment required hoti hai.
Sir,
Faisal, I have a question.
Sir.
First of all, you'll have to take us through this concept of constitutional absences through a text of any book which says
I'm taking you to a judgment.
नहीं उसके अलावा where is it as a text?
Sir, उसी में वो text mentioned.
Judgment में खुद ही लिख दिया होगा.
नहीं.
Where is they borrowed it from what text?
Sir,
so where is this principle?
There's a Harvard graduate or a professor saying something.
Or maybe of any other.
मैं
ऐसे वैसे एक चीज पूछ रहा हूँ वो तो आप बता दें हमें So suppose if there is such a doctrine, the constitutional absence has to be filled through judicial engineering, as you say. So one engineering was done in Samiullah, and one straightforward answer was that a declaration will continue until such time that the declaration is set aside. Is a straightforward, quite simple interpretation of filling the absence. You say, no, there could be yet another one, which is that he's disqualified for that election, which I find out in the two to be slightly more difficult one. The more easy one is the one that the declaration holds for such a time. I mean, if you're filling the absences, the more straightforward filling of the absence would be that the declaration continues. अब आप उसके ऊपर आपकी जो carving है, आप
नहीं, मैं उस पे मैं क्यों कह रहा हूँ, मैं उस पे आता हूँ.
Where do we draw the line?
No, मैं उस पे भी आता हूँ.
Or is there a third option that please send it to the parliament, let the constitution be amended accordingly and sort that out? Why should we get into the business of filling the absences, and where do we take the concept of causes omissus? Please अभी जरा doctrine तो पढ़ दे.
जी सर.
Where is this doctrine?
मैं फिर इन सवालों का जवाब
पहला doctrine बता.
जी. If your lordship may see, this is a very famous judgment of Manoj Narula, in which the petitioners also.
If you say so. If you say so.
No, in which the petitioners also wanted the court to read a certain disqualification in a constitutional absence in the constitution, and the court refused. If your lordship may kindly see page 21, bottom पे लिखा हुआ है sir pages.
जी.
Now, मैं सिर्फ आपको बता देता हूँ, इशू ये था कि criminalization of politics को रोकने के लिए the petitioners wanted the court to say that even if a charge has been framed in terms of a heinous offense, that person should not be appointed as a minister. Now, this discusses this doctrine of constitutional silence. Bottom of the page. Principle of constitutional silence or abeyance. The next principle that can be thought of is constitutional silence or silence of the constitutional or constitutional abeyance. The said principle is a progressive one and is applied as a recognized advanced constitutional practice, has been recognized by the court to fill up the gaps in respect of certain areas in the interest of justice and larger public interest. Liberalization of the concept of locus standi for the purpose of development of the public interest, to establish the rights of the have-nots or to prevent damages and protect environment is one such feature. If your lordship may come to para 50, para 49.
There's no reference to this principle.
Sir, apart from the aforesaid reasons, उन्होंने judgments भी refer की हैं. अब मैं text की बात कर रहा हूँ. The arguments by the apparent cannot be accepted in view of the well-known constitution.
Which paragraph are you reading?
Para 49, sir. Page 22. Para 49.
Para 49 तो कोर्ट है.
मैं अगर पढ़ दूं वो जजमेंट्स में से कोर्ट किया जो जज.
Okay.
Of the well-known constitutional doctrine, namely the constitutional doctrine of silence, Michael Foley, in his thesis on the silence of it's the most famous book on constitutional silence, has argued that in a constitution, अब ये बड़ा important है sir, in a constitution, abeyances are valuable. Therefore, not in spite of their obscurity, but because of it. They are significant for the attitudes and approaches to the Constitution that they invoke, rather than the content or substance of the strictures. Agar main para 50
this means that the silences have an importance.
Yes.
And they should be left silent.
नहीं, ये नहीं है. So para 50 देखिए. The learned author elaborated this concept further by saying that despite the absence of any documentary or material from these absences are real and are an integral part of any constitution. What remains unwritten and indeterminate can be just as much responsible for the operational character and restraining quality of a constitution as its more tangible and codified components. The question that is to be posed here is whether taking recourse to this doctrine for the purpose of advancing constitutional culture, ये बड़ा important लफ्ज है. Can a court read a disqualification to the already expressed disqualifications provided under the Constitution and the 1951 Act? This is their election. The answer has to be in the inevitable negative. For there are express provisions stating the disqualification, and section it would tantamount to crossing the boundaries of judicial review. So, my submission before your lordship is कि इसको easy नहीं लेना चाहिए कि legislature ने कोई चीज जानबूझ के छोड़ दी है. अब वो gap fill किस तरह करना है, that is where the doctrine of constitutional implication comes in, which is the next paragraph. Doctrine of constitutional implication. The next principle which we intend to discuss is the principle of constitutional implication. And to save time, my lord, I'll jump to the next page, page 23, third paragraph. There is no speck of doubt that the court has applied the doctrine of implication to expand the constitutional context, but the context in which the horizon has to be extracted has to be borne out in mind. What is suggested by Mr. Dwivedi is that by taking recourse to the said principles, the words employed in Article 71(1) are to be interpreted to add a stage in the disqualification, i.e. framing of charges in serious and heinous offences or offences relating to corruption. At this juncture, it is seemingly to state that the principle of implication is fundamentally founded on rational inference of an idea from the words used in the text. The concept of legitimate deduction is always recognized. In Melbourne Corporation versus Commonwealth, Dixon J. opinioned that constitutional implication should be based on considerations which are compelling. Mason CJ in political advertisement case has ruled that there can be structural implications which are logically or practically necessary for the preservation of the integrity of the structure. Any proposition that it arrived at taking this route of interpretation must find some resting pillar or strength on the basis of certain words in the text or scheme of the text. Now, to have constitutional implication by reading 62 and 63 all together, would I think...
Let's assume there is no Samiullah case. There is no section 232.
मैं ये तीन लाइनें पढ़
Then what is the literal interpretation of 62 and how you will disqualify the person?
सर मैं तीन पढ़ लूं?
जी.
In the words in the text.
Could you read Mason CJ से आगे?
Sir, ये तीन लाइनें बहुत important है. In the absence of that, it may not be permissible for a court to deduce any proposition as that would defeat the legitimacy of the reason. A proposition can be established by reading number of articles cohesively, for that will be in the domain of substantive legitimacy. Yes. Now this is the problem with the court. It recognizes there is a constitutional absence, it engages in the doctrine of constitutional implication, and then comes to the conclusion that there is only one implication possible without justifying it in terms of a overall reading of various interconnected articles, especially 63, especially 17. I think the reading of both is wrong. Now, अब सर अगर आप 62 1F पे मैं अगर आपको ले चलूं, after I have established the doctrinal basis of my argument, if your lordship may kindly see.
नहीं ये 62 जो गैप था ना, इसको किस तरह फिल करना है? मतलब आपने कहा ना कि
सर मेरा ये कहना है
62 1F के अंदर अगर समीउल्लाह भी ना हो और अभी ये 232 भी ना हो, तो अगर आम हालात में इसको पढ़ा जाता तो आप कैसे डिस्क्वालीफाई करते उसको? इलेक्शन टू इलेक्शन करते, एक साल के लिए करते,
जरा सा 62 1F पे आ जाए, मैं उसी वक्त एक्सप्लेन करता हूँ अगर मैं आ जाऊँ.
So are you saying that when there is a constitutional absence, it can only be filled by the legislature?
No, I'm saying if the court in the meanwhile fills it, it must be very conscious of the fact that since it's an absence left by the legislature, any interpretation which gives that absence a permanent character would be a violation of the constitutional absence which is left by the legislature.
Okay, now if there's a constitutional absence and the court fills it in, both the court and the legislature can do so.
Yes.
Correct?
Yes.
Which will prevail?
Legislature can't. Well,
one does this thing, the other does this thing.
Legislature can't, as far as the constitution is
Which will prevail then?
Sir, देखिए, मैं example के through quote करूँ.
कैसे भी आप करें.
If the court
both does it.
हाँ.
आज हमने एक इंटरप्रेट किया कोई चीज और आज ही हमें पता नहीं था, बराबर में पार्लियामेंट में एक लॉ बना दिया, हमें पता ही नहीं है, एक दूसरे को कुछ नहीं पता है. हमने भी वही काम कर दिया, उन्होंने भी वही काम कर दिया. मैं आपको who will prevail
concrete example देता हूं जिसमें there will be no contradiction of prevailing. For example, अगर 1F को पढ़ा जाता, 62 1F को पढ़ा जाता, not as implying any kind of permanent disqualification, simply a disqualification which is about that election. It is a disqualification.